Hoje vamos ouvir o professor Lanny Breuer falar sobre corrupção e as medidas de prevenção de corrupção e seu impacto no mercado brasileiro. Esse debate é particularmente importante nesse momento, tendo em vista não só o julgamento de uma grande ação penal pelo Supremo Tribunal Federal, no qual se discutiu bastante o tema da corrupção, seguido ou simultaneamente com os movimentos populares pedindo a punição e o combate à corrupção, e, finalmente, a lei de responsabilidade por atos ilícitos contra a administração pública, que vai mudar bastante o cenário do compliance anticorrupção no Brasil. Então, eu fiz essa breve introdução em português, vou apresentar o professor Breuer em inglês. So, Dr. Breuer previously served from 2009 to 2013 as Assistant Attorney General for the Criminal Division of the U.S. Department of Justice. In this role, he has widely recognized as a national leader on a range of federal law enforcement priorities, including FCPA, money laundering, financial fraud, and public corruption. While at the Justice Department, he spearheaded the publication of the Resource Guide to U.S. Foreign Corrupt Practice Act, which stands as the definitive guidance document from the United States government regarding the enforcement of the FCPA. Besides many other remarkable achievements, Mr. Breuer served as a special counsel to President Clinton, representing the White House in investigations by the Independent Counsel, Department of Justice, and Congress, and defending President Clinton in impeachment proceedings. He is here today to talk about global anti-corruption regulation, the impact on Brazilian and international companies investing in Brazil. Our law school is very pleased to have you here, and please, the floor is yours.
Well, thank you for having me. Thank you so much. I don't speak a word of Portuguese, but I did hear professor and doctor, so it sounded pretty good. I'll take all those promotions. So obviously, I've never before been in Brazil or São Paulo, but I'm delighted to be here, and it's such a prestigious institute. I know your law school is one of the finest law schools in the country. Your think tank, the Institute, is one of the finest as well, not just in the country, but in the world. And so I very much look forward to having a discussion with all of you today. And what I thought I would do is chat for a little bit, give you some perspectives, and then we can open the floor in any way that you want. As you heard in my introduction, I very recently came back after heading up the criminal division. I was fortunate enough that President Obama asked me to be the head of the criminal division, and I was confirmed by the Senate. And in my career, I've been able to go in and out of government. The only law firm I've ever worked with is Covington and Burling, but as I said to a legal periodical in the United States most recently, that was when I returned to Covington. It was my first day at Covington. And in the United States, we have a tradition that you may not all have here. I don't think you do, and I'm happy to chat about it later, which is the tradition of lawyers such as myself who go in and out of government. So before I was the head of the criminal division, I was very fortunate to have a large, what we call in the United States, white-collar criminal defense practice that I headed up at Covington. And for many years, I defended individuals, prominent individuals, and government officials and corporations in many investigations, FCPA, corruption, but a whole variety. And from my perspective, but it could be a topic we talk about today, that enabled me to be a better assistant attorney general because I'd been on the defense side, and I think it makes me a better defense lawyer having been the assistant attorney general and having begun my career. I began my career as a prosecutor in New York. So I prosecuted crimes in New York, then I went to Covington, then I went to the Clinton White House, then I went back to Covington, then I went to the Department of Justice. Now I'm back at Covington. So for those of you, many of you look young, I know I must sound like I'm about 118, given how many times I've gone back and forth. So today what I thought I would do before talking about corruption generally is I wanted to orient you. So I was the head of what we call the criminal division. And in the United States, the criminal division in Washington, D.C. has approximately 600 lawyers, about 1,100 people. And those prosecutors do everything. They prosecute, there are sections that prosecute organized crime and gangs. There's a section that prosecutes those who are involved in dangerous drugs. And we spent a lot of time, for instance, in Mexico, dealing with the cartels of Mexico, but dealing with those who sell drugs in the United States. There's a section that deals with intellectual property and cybercrime, which is an exploding area, and we prosecuted those who steal intellectual property and those who are involved in all kinds of aspects of cybercrime, whether it's sending botnets through the internet or the like. So you really see in this job as the AAG a whole range of crimes and a whole range of investigations, both domestically and, frankly, internationally. There's a very large international component that I'll chat about. And then in addition, in the United States, in addition to the 600 lawyers in the criminal divisions, we have in every state federal prosecutors in what we call United States Attorney's offices. And there are actually 50 states, but there are 94 U.S. Attorney's offices, and each one of those has someone called a U.S. Attorney, and the criminal division effectively partners with those U.S. Attorney's offices. And that's how you bring many of the kinds of cases and the kinds of cases that we'll speak about today. Now, in the United States, we have a law called the Foreign Corrupt Practices Act. And the law is unique in certain ways, but one reason it's unique is that no case in the United States can be brought, any case under the FCPA, as we call it, unless the criminal division approves the case. So if you're in Houston, Texas, or you're in New York, or you're in South Carolina, if someone wants to bring an FCPA case or investigate you, the criminal division that I headed up has to approve it. And therefore, in the 4 years that I was the Assistant Attorney General, from '09 until just a few months ago, the criminal division and ultimately the AAG has to approve all of those cases. Now, the FCPA, I think, is the hallmark of how the United States deals with corruption in an international setting. But we don't just deal with international corruption, we deal with domestic corruption. And as I was talking to you about all the different kinds of work that the criminal division does, there is one section called the Public Integrity section. That's a very elite section of roughly 25 to 30 prosecutors. And all that the Public Integrity section does is investigate and prosecute U.S. public servants. So if you're a public official in the United States and there's an allegation that you've engaged in corrupt conduct, there's a real likelihood that the Public Integrity section, either by itself or with those U.S. attorneys' offices that I mentioned to you, will be involved in the case. And for instance, recently, there's no reason any of you should know it, but a congressman by the name of Jesse Jackson, he was the son of Reverend Jackson. Reverend Jackson had once run for president. Jesse Jackson, the congressman, tried very hard to succeed Barack Obama as the United States Senator from Illinois. Barack Obama, before he gets elected president, was one of the 2 senators from Illinois. When President Obama got elected president, there was, of course, a competition to see who would succeed him as the senator from Illinois. Jesse Jackson Jr. was one of the people who tried very hard to get that position. He was recently prosecuted for receiving bribe payments. We even brought a case against John Edwards, who had run for vice president and had run for president. And so the notion is that what we're going to talk about in the foreign context, the United States Department of Justice attempts to do domestically. And so one of the themes about the FCPA is that for most of history, there was nothing that made bribing a foreign official against the law. Anywhere in the world. And indeed, until the 70s, business on an international level was often done by competing, by bribing a foreign official. So a Brazilian company and a U.S. company may compete. They may be trying to do some business in Asia. They want a contract in Malaysia. And one of the ways they compete is they both bribe the government official in Malaysia. And then in the 1970s in the United States, we had a huge crisis, a political crisis of enormous import. We had a president, President Nixon, who had to resign in disgrace for acting in a corrupt manner. And that was really, for the United States, a remarkable moment of introspection, great concern, division, and a level of shame. And so the country and the government, many of you probably weren't even born in the 1970s, but the United States had an introspection about what to do. And there was a study done, and there was a determination made that we ought to make bribing foreign officials against the law. And the theory was, if you're not allowed to bribe the mayor of New York City to get a contract, you shouldn't be allowed to bribe the mayor of Sao Paulo to get a contract if you're an American citizen. We should do it the same way. And we have the public integrity section that is going to prosecute people for being corrupt public officials in the United States. We ought to deal the same way with those people who are going to do it on an international level. So a law was passed, Foreign Corrupt Practices Act, and it said, basically, you can't do it. You can't bribe foreign officials. But you all know, those of you who are lawyers or those of you who are law students, that that's only the first step. The first step is writing a law in the books. The next step is, are you going to enforce the law? Are you going to actually do something with the law that was written? And frankly, for the first 25 to 30 years of the history of the FCPA in the United States, there was little or no enforcement. It was on the books. It was against the law. But the criminal division wasn't particularly involved in bringing these cases. I mean, like everything, you have resources. If you're the head of a division, you have to decide where are we going to put our prosecutors, what are they going to focus on. You don't have unlimited resources. U.S. attorneys weren't bringing these cases. So there was very little enforcement. And then in sort of the mid to late 90s, there was a little bit of enforcement. I actually was involved defending one of the first FCPA cases. Then in the early 2000s, there began to be more and more. But when I came on board in 2009, the President and the Attorney General made it clear, and I wanted to, and I felt strongly, that fighting corruption domestically and internationally should be a priority of the United States. And when I had to be confirmed in the U.S. Senate, the senators asked me in this context and in many contexts whether or not we would hold individuals themselves accountable. Individuals. So if you're a wealthy executive and you're in the country and you're involved in these kinds of efforts, you're involved in bribing officials, will we hold you accountable? And by any measure in the United States over the last 4 or 5 years, there's been an exponential increase in the enforcement of the FCPA. Since around 2009, some 50 executives have been prosecuted. A good number of them are in jail today. Major corporations have been prosecuted. The fines have been extraordinary. The remediation has been extraordinary. And so one piece of the puzzle of fighting corruption for the United States was the enforcement of the FCPA. And today, by any measure, there are certainly very few Western-oriented companies, certainly virtually no U.S.-oriented companies on a major scale that aren't aware of the FCPA, that don't have strong compliance programs in place, don't have strong remediation programs in place. There are few American companies, when they do transactions internationally now, that don't think of the FCPA, and if there is a problem with corruption, how can they remediate it? Similarly, what we did in the United States was we started a new initiative that I got the Attorney General to agree to. So under the FCPA, it's against the law to bribe the foreign official. Now, if you're the foreign official, there are other laws that we can perhaps prosecute you with. But one of the phenomenon that I identified in the United States was that we would have wealthy foreign officials who made relatively little money, and yet they'd come to the United States and they'd live like gazillionaires. And so there seems something wrong about that. If we think it's against the law, you shouldn't be able to park your money in the United States. It shouldn't be the haven for where you've taken your ill-gotten gains and parked them. And so we began a civil initiative because we didn't always have the ability criminally to go after you. But we began something called the Kleptocracy Initiative. And a kleptocrat, kleptocracy in the English language, means a government official, a leader, who basically steals from his or her people. And so we began an initiative. I recruited 6 or 7 incredibly bright attorneys to be involved. And we filed our first cases. And the first major case was against a minister named Obiang from Equatorial Guinea. And Minister Obiang of Equatorial Guinea, we allege this in the court papers, so I can say it, is the son of the president and the minister of the interior in Equatorial Guinea. And his salary for being minister is roughly the equivalent of $60,000 or $70,000. But he bought a $35 million mansion in Malibu in California, and he bought a $32 million Learjet. And maybe he's got a better investment advisor than I do, but for the life of me, I couldn't figure out on $60,000 or $70,000 a year how he did it. So we alleged in papers that he had stolen the money from his people, and we have now filed, well, the department, while I was there, filed to seize his mansion. And if we can get his jet, to seize his jet. And the theory is, if the Department of Justice succeeds, it will hold it. And then at some later point, we'll figure out a way, when it can, to return that money to the citizens of Equatorial Guinea, or to put the money in some sort of international body that somehow can ensure that that money goes back to its citizens. So I bring that up because it's another way that we in the United States, while I was AAG, tried to deal with this issue of corruption. And then what we did was, with certain countries, is we sent lawyers to work with countries that were either at early stages of developing laws, such as the law that you all have just passed in Brazil, or with prosecutors who wanted to begin prosecuting these cases. And so with what we call resident legal advisors, prosecutors who live in countries for a year or 2 or more when the country's asked, it typically, candidly, are not countries like Brazil. It tends to be countries that are not as well off as Brazil. But we worked with countries to help them devise new laws and to deal really with the issue of how they themselves can enforce these kinds of laws. Now, the FCPA, we take the United States, not surprising, it's probably the United States personality, the United States takes a very large view of its jurisdiction, very large, right? And some people could criticize it, but the law basically says if you're a Brazilian company but you hire a U.S. business person, we have jurisdiction. If you're a foreign executive, you're a Brazilian, but you work for a U.S. company, we feel we have jurisdiction. If you were involved in a deal, you're a Brazilian company and you bribe an executive in Kazakhstan, but you had a meeting or two in the United States to talk about this, or you used an emails where the servers are in the United States and you may not even know it, or you use the financial institutions and the money is routed somehow through the United States, that's good enough for the United States. We feel we have jurisdiction. And so I bring that up because it's an incredibly large area. The first case, I did a case once when I was in the private sector of a very prominent Egyptian businessman who in fact was doing business in Kazakhstan, but one of his partners, it ended up, he was completely exonerated. He didn't do anything wrong, but he was investigated. Egyptian businessman, Kazakhstan investment, but in the course of 2 years, there had been 2 meetings dealing with this investment in the United States. And those 2 meetings, which were very short meetings, was enough to give the United States a nexus. So one of the reasons I bring it up is that the FCPA has a very large jurisdiction. But what I had said and what I think you're going to see, and it'll be interesting to see what happens in Brazil, is while I was AAG, I kept saying there's going to become a time pretty quickly when other countries are going to begin to really enforce these same kind of laws. And when they start enforcing the laws, then the U.S. has to take sort of a hard look and say, do we really have enough of a hook here that we can, under the law, we can prosecute and investigate, but should we? Or should we defer to another country because that other country has a stronger interest? And I think what my view was when I was Assistant Attorney General, and I suspect what my successor will think, and certainly what the prosecutors will think, is as long as someone is dealing with the issue, then it doesn't have to be the United States. And so recently, about 2 months ago after I had left, but in a case that I had been involved in, something happened that frankly wouldn't have happened 4 or 5 years ago, which was on the very same day, the United States announced the resolution of a case dealing with a French company, and the French prosecutors announced the exact same resolution from the French perspective. And so it was a true partnership. And if you go back, you'll see that years ago I said, when I started the job, that I looked forward to the day that we were going to have joint press conferences talking about how we as a partners sort of divided up a case because the French, or the Brazilians, you pick your country, had an interest, and we had an interest. The U.S. did one piece and they did another piece. And so I think you're going to see more and more of that as more and more countries get involved. And so while I was AAG, I traveled really all over. I traveled to Russia, I traveled to Ghana, I traveled to Liberia. And the reason I bring it up is that different countries have different abilities now to prosecute these kinds of cases. And when I was in Liberia, I had the honor of meeting the president of Liberia, and she's really an extraordinary woman, Ellen Johnson Sirleaf. I don't know if many people refer to her as the female Nelson Mandela. She's just an extraordinary figure. And when I met with her, she said, listen, after the tragedies of my country, after the wars in my country, we're trying to build the infrastructure. And if you could help us in one way, the one way you could help us is by helping us fight corruption. The last thing I want as we begin our nation is for foreign companies or other actors to come in and start bribing our officials to build here. we've had so many disadvantages. And so enforcement of the FCPA, frankly, in so many ways, I think is essential. And the enforcement of the kind of laws that you all are thinking of, I think, is essential. If you, in my stream of conscience, just for 2 more minutes, if you do take a step back and you look even in what's going on in the Middle East the last few years, there are a million reasons why things like the Arab Spring have occurred. You can argue whether you think it's a good thing or a bad thing. You can argue all the motivations. But for sure, one of the reasons why the Arab Spring started, and it started in Tunisia with a local fruit merchant who was selling his fruit and wares, and a local corrupt inspector came and she humiliated him and tried to extort and take from him, and he finally set himself ablaze. And then the country started protesting, and from there it all occurred. One reason was because of just corruption. And a generation, maybe of some of you, or people maybe even younger than some of you, a generation of young people said, you know, we just live in a fundamentally corrupt country. No matter how elite the school we go to, it doesn't matter. We probably can't even go to the school no matter how smart we are. No matter how hard we work, it doesn't matter. What matters in our country is how connected you are. What matters is who your parents are. We're sick of it. We want some opportunity to benefit ourselves by how hard we work, how industrious we are. And that's really at its core what the FCPA is about, what I assume your new statute is about, what our corruption statutes are about in general, which is to say public servants need to be working for the good of their people, not for the good of themselves. And people should succeed because of how hard they work and how smart they are and what they're doing, not because they know who to bribe. And so I felt very strongly and was very proud as AAG that we in the United States expanded the prosecutions of the FCPA, began the kleptocracy initiative, sent resident legal advisors around the world to help other countries if they wanted to do it, worked with other ministers of justice and prosecutor generals so that now in France or in England or China, you pick your countries, you're seeing in China today they're doing more just in the last few months in this space than they've ever done before. I'm not talking about the merits of the case, I'm just talking about countries now filling up that space. So I think if you look at the wave of where things are going, countries are going to more and more do what Brazil is doing now. I think the challenge is for a country like Brazil will be, what does the law say? How are you going to enforce the law? Are you going to enforce the law? Do you have prosecutors who are skilled enough and empowered enough to go head-to-head against lawyers for big companies? And I say that now that I'm a lawyer for a big company, but when I was the AAG, we recruited senior lawyers. I recruited both senior lawyers who were prosecutors, but frankly, senior lawyers from some of the most elite law firms in the United States. And I said to them, look, why don't you do what I do? Why don't you take a few years off from your practice and come to the government, serve President Obama and the administration? And there's just no question that in the United States, that worked dramatically well. And you can look at the results by looking at what was accomplished. So the challenge for Brazil is, how do you implement it? Do you do it fairly? Does the citizenry, do the citizens perceive that the law is a fair law, that it's being enforced impartially, that it's really going after corruption? Because at the end of the day, I think that if there's a perception that, in fact, prosecutors are impartially going after corrupt officials and those who would bribe them, I think there will be a sense that the law is doing what it needs to be doing. And look, in the United States, there's many injustices in the United States. We obviously have many problems. But there is a perception, and I think it's based on reality, that for the most part, when public officials try to engage in corrupt activity, if we find out about it, they will be prosecuted. And there are many public officials, federal public officials, state public officials, local public officials that are sitting in jails today as a result of that. So I've lost track, but I've probably gone about 30 minutes or so, and I don't want to go too far. But I guess what I'd say is I'd be delighted after the critique and the comments to answer any questions you have on this issue or really any other issues that may be of interest to you. So thank you all so much.
Thank you very much. And now we have two specialists to present some comments and questions. On the right side is Carolina Yumi. She's a federal public lawyer in charge of the corruption cases on the administrative level. She'll be actually one of the ones responsible for enforcing and implementing the new legislation next year. And on the right side is Ana Belotto. She's a lawyer specialized in compliance and anti-corruption, and you're also a counsel for U.S. legislation, isn't it, Ana? So you can explain it better later. Okay. They are going to make some comments and put some questions for you.
And thank Dr. Lanny for your very enlightening speech. Actually, with this new law we are talking about, I think I have to agree with you that our biggest challenge is figure out how to enforce this law and the other many laws we have against corruption. As we're telling, recently Brazilian Congress has passed a law against corruption, introducing many new institutes to control and punish national and foreign corruption, and especially concerning companies. Among these institutes, the possibility of condemnation of these companies in the civil and administrative areas. Because I don't know if you know that, but we don't have the possibility to, we don't have the responsibility for companies in the criminal field. So this will be a very big change for us. The fine that we can impose in this new law may reach 60 million reais, about $25 million, I think. Other important aspect of the law is that because we're talking about a civil proceeding, the government will not have to prove deceit or bad faith in order to obtain a condemnation. And there is also another innovation. If the company has compliance programs or has enforced procedures to identify the people involved and has provided the government with important documents, it may have the fine reduced. Because this is an innovation, we have many concerns about the enforcement of these laws. But one of them is about the condition of the employees, about their rights. Given that this law will encourage the investigation inside the companies, how USA has been facing this issue? The issue of the guarantees of the employees. For example, the company has the right to access employees' emails or other information. Another slight comment and a question. And do you think this kind of law that strengthens the government powers and enlarges the ways of control improves the trust of international companies in local governments or move away foreign investors?
You're an employee of a company and you realize that in connection with an investigation or something that the company can access your emails. And of course, I don't know what you do in Brazil, but of course in the United States, there's really no company in the world that doesn't, in the very beginning when an employee gets retained, tell the employee and writes down that the emails and materials of the company belong to the company, not the individual. So when we investigate these things and we look, and usually in an investigation, what will happen on the defense side is there'll be an allegation, a specific one. The first thing you'll attempt to do is to try to figure out who are the individuals who might have some knowledge or might have materials that pertain to this. Now, maybe it's a big group, maybe it's a small group. And then the second thing you'll do is you'll try to narrow it. And then typically what you would do is you would do electronic keyword searches. So you know, you're not going to pick up, hopefully, the emails between employee and her husband or her boyfriend talking about where they're going to dinner. Hopefully you're going to pick up in the electronic searches those documents that deal with the subject matter. So that's how you do it, but at the end of the day, you cannot have a system, you just can't have a system that promotes, in my mind, honesty and integrity if people know from the start that whatever they say, nobody can look at. There has to be, law enforcement just has to have the ability. Now, I'm not saying, I mean, obviously this is now controversial. You know, in the United States, there have been examples probably where it's gone overboard in a totally different context than what I'm talking about. But if you have probable cause that a crime was committed, if you believe that, let's say, a FCPA violation was occurred, then I think a company has to have the ability, and the government definitely has to have the ability to try to figure out whether that's occurred or not so it can right itself. And there's no alternative but getting the documents. And then, frankly, also interviewing the people. And when you interview the people in the United States, just so you don't think these are easy, you say to the employee, you know, employee, I'm going to now ask you about the allegations about bribing of the official in country XYZ. And if the employee says, you know, I don't want to answer that, I think it might incriminate me, in the United States, you can and probably should fire that person. You can't force him to incriminate himself, but you don't have a right to not answer a question like that for a company and also remain employed. And so your question's great. These are very hard issues.
I'd like to also thank for the invitation. Thank you for the attention. Thank you very much for your speech. It was very very educative, and also I work on the side of compliance at a law firm, and I can say that we feel every day the effects of the FCPA here in Brazil. Most of our clients are companies that either do business in the United States and feel they're subject to the FCPA and want to implement compliance programs in Brazil. American companies that come to Brazil, and they either through mergers or acquisitions or joint ventures want to implement their compliance programs into the Brazilian partners. And also companies in Brazil that may not have be subject so obvious to the FCPA, but they want to implement compliance programs to become more attractive to foreign investors. So we do this every day, and really, I mean, today I can say that the reason why companies look for compliance programs is much more because of the FCPA and now the UK Bribery Act, and because of Brazilian internal laws. We have this new law now, but I mean, corruption is not a new issue in Brazil. We've had it, I mean, it's a crime in our criminal code for a long time. We have the administrative improbity law that can also go after companies, which is a civil law. We have the our public contracts law that also has crimes that are related to corruption. So I mean, the concept is big, but I feel there's still a big sense of impunity in Brazil. People are not so scared of Brazilian law and Brazilian enforcement, especially as they are when it comes to the FCPA. So I believe there's a new culture in Brazil, and this idea of looking to the company, not so much to the public agent, as a way to fight corruption. So changing the sides a little bit. My question, having made that comment, is see where do you think the United States is going now? We adopted a law that is not, I mean, has some similarities to the FCPA, adopts the idea of the compliance program, also adopts the idea of negotiating, so self-report, which I think has been very important in the FCPA when the companies come forward. But it hasn't gone as far as for compliance programs as the UK Bribery Act, for example, where you having a compliance program can be a full defense.
Right.
Bringing in the concepts of commercial bribery, staying not so much with the public sector, but also bringing the private sector. Do you think this is something that...
So, in the United States, I would have said, and I would still say, that if you come in and you disclose, we just discovered that there's a problem, I always said, if you voluntarily disclose, we'll treat you more leniently. And I also always said, and we say in the Department of Justice when I was there, and they still do, that if you have a compliance program, a program to try to stop corruption from occurring, or if it occurs to try to mitigate it, that that's a factor towards leniency. Now, the UK Bribery Act is much newer, and they took it one step further, and they said, if you have a compliance program, you get a pass. Under certain circumstances, you just get a pass. You have it, you built it, you did it, you have clarity. So I was asked when I was AAG repeatedly, you know, whether the United States would do it, and my answer was, well, that's up to Congress. I don't get to make the laws, I only get to enforce it. But I was against it, and I remain against it. And the reason I remain against it is I'm worried that if you have, and I thank you for what your comments are about, like in Brazil, how they've reacted to our enforcement in the FCPA. My view is if the United States had what the UK's imposed, and fair-minded people can disagree, that it'll be a race to the bottom. Everybody will try to figure out what is the absolute minimum compliance program I can have so I can go in and say, so you see, here's my compliance program, I get to walk. And I don't think that's particularly healthy. And then we would be in court in the United States saying, your compliance program is terrible. It's not, it's a joke. And they'd say, what do you mean it's a joke? It's a compliance program. It says right up there, compliance program. We get a pass. And so what I want is I want the department, and I even say this as the former Assistant Attorney General, to have maximum discretion. Now, it's on the government to use its discretion, to be fair, to be just. But I don't ever want the United States to be in a place where it's automatic, check the box, we're there. And, you know, in the United Kingdom, and I have dear friends there, David Green, the head of the SFO, is someone I know well. They're new to it. They really haven't enforced very many cases, so there's no way to test it. So I can't say that in the United States we'll never do it, because many people shockingly disagree with me in the United States. But I, for one, did not support it. I didn't support it. I know that the Attorney General, who I'm very close to, didn't support it. And so I think that's really the debate on that issue.
Now we are going to open the microphone for the audience, if someone has there.
Thank you. And by the way, visit to Brazil, that's great, to right at the, before our law is even factored. Great educating opportunity for all of us. But I was going to ask you, and I think that there's a discussion going on in relation to our own law about the intention element, because we have strict liability and the qui pro quo. So if you could elaborate a little bit. The reason why I ask you is because I worked on a case very recently where U.S. Consul made us put together a spreadsheet where we would list the the actions of the government official that actually got accomplished, or in other words, obtained, the company obtained some advantage or maintained some business, the quid pro quo element. So if you could elaborate a little bit on that, I really appreciate it.
Sure.
Thank you.
So let me just begin by saying I'm not an expert on the Brazilian law at all, and I'm not commenting on the Brazilian law because I just don't really know it. And I also said, as I said at the beginning, I think there are a lot of ways that different countries can make these judgment calls on how to get to the same place. And for instance, just to give background, we talked for a moment about the compliance program, and another example is in the United States, much to the criticism of the rest of the world, the FCPA permits something called a facilitation payment, which basically says, I won't go into too much, but basically says if you're entitled to something, you're entitled to get your driver's license, you filled out the form for your driver's license, you did everything, and in this country, if you're going to get your driver's license, basically you have to give the person behind the counter $10 or you're not going to get it, and everybody knows it. In the United States, that's called a facilitation payment. It's okay. In most of the world, they say no, it should be a crime. It's against the UK Bribery Act. So they're judgment calls. So with that caveat that there are different ways of doing it, in the United States, in our criminal law, with very few exceptions, there are a couple. They tend to be in the health area and in the environment area. There is what we call in the United States rarely the idea of strict liability. Strict liability means you did it. We don't care what was in your head. We don't care if you intended to do it. If you were negligent, it happened, you're liable. There are some criminal laws in the United States, again, mainly dealing with health, because we care health and safety, health and environment, that permit strict liability. But in the real world, remember I talked about enforcement, almost never, because they're so controversial, not never, but almost never are those laws enforced. So it is sort of an essential element to the United States criminal justice system that if I'm going to try to put you in jail, I ought to be able to prove beyond a reasonable doubt that you intended to commit the crime, or at minimum, you had what we call a conscious disregard. You closed your eyes, and I didn't know that the crime was committed because I closed my eyes and I closed my ears. But it's at that level. And so I've grown up in a world that sort of more is comfortable with intent crimes, or at minimum, conscious disregard crimes. But then, if you did it, you ought to go to jail. So we don't really have the concept that much in our country of strict liability, and so, I'm not comfortable with it, and probably my first reaction is I don't like that. With respect to quid pro quo, you do violate the FCPA in the United States if you intend. You don't have to complete the crime. So if I say, here, I'm going to give you my watch, if you do this for me, Mr. Government official, if you took my watch but you didn't do it, too bad for me, I've still violated the law. But when I give you my watch, I have to have a corrupt intent. That's the key to the FCPA. I can't give you the watch because you're a good government official and I really like you and I want you to do well and maybe you're going to do. I have to have a corrupt intent, that my intent is I'm giving you my watch and you're going to do something for me, quid pro quo. So the idea of a quid pro quo is very much at the heart of the FCPA. It doesn't have to be completed, and that part I think is very good.
Right,
so.
That's the difference with our law then,
Right.
because our statute doesn't really require complete quid pro quo.
Yeah, so ours requires the intent, the corrupt intent, which I would equate to sort of a quid pro quo. I'm giving you something corruptly, and if I'm giving you something corruptly, the corruptly presumably means I want something in return, right? That's why I'm doing it. So, and I think that's probably about right.
I thought it was very interesting when you told us about the history of the FCPA and the Watergate episode. And while I was listening to that, I was thinking that maybe we've reached a point where we can say that there's actually a trend worldwide in fighting corruption, right? Not only foreign corruption, but corruption in a broader sense. In recent years, we've had China, Mexico, Russia, now Brazil, so a whole lot of countries enacting legislations against corruption. And since you've mentioned that your intention or the intention of the U.S. government would be to partner with other governments
Right.
in international cases. My question would be, how would that work in practice? Like, for example, we can have a case where a company would be subject to 3 or even more different legislations, anti-corruption legislations. So how would that work in practice? Would this company be subject to 3 or 4 different fines? Would the U.S. government take that into account when defining the amount of the fine
Right.
in a case like that?
So I don't think the U.S. government would ever, probably ever sort of micromanage what a country does. So the way it would really work is, let me take a step back in a totally different context. When the United States finally effectively started fighting organized crime, like the traditional in America for a long time ago, was sort of Italian organized crime. The way it really effectively ultimately did it was we partnered. Again, there was a big event. Judge Falcone, a very famous judge in Sicily, was murdered. The people of Sicily were finally outraged. After years and years of organized crime, you're all wondering, what does this have to do with what we're talking about? But give me a minute, you'll see. And the people of Sicily, finally, after years and years of suffering under organized crime, were outraged when Judge Falcone, who was the main prosecutor, and his wife were on a bridge. They were coming home. Organized crime blew up the bridge. They killed the judge. They killed his wife. The next day, 10,000 people in Palermo marched the streets and basically said, enough. They finally had courage. When that happened, in the United States, we too had been dealing with Judge Falcone. And immediately, the United States partnered up with the prosecutors in Italy and began almost in unison bringing these cases in the United States and Italy. You had these families, they had a U.S. branch and an Italian branch, and there became this never-ending exchange of information, and there were these huge cases brought in Sicily, there were these huge cases brought in the United States, and not that organized crime is solved forever, but at least in the United States, traditional organized crime is dramatically, dramatically different from what it was decades ago. So you can partner up with countries when you know the prosecutors. And one of the reasons I sent resident legal advisors, frankly, to live in other countries was because they're young prosecutors. Many of them will stay prosecutors. They'll know their counterparts in the other country. And like anything in life, some level of knowing each other and trust works. So what will happen in the evolution, or what happened like recently in France, or what's happening in Germany now, is that when you have a case, and maybe you have a German company that had some dealings in the U.S. and is being investigated for bribing, let's say, since you said Mexico, Mexican officials. I have limited resources. They have limited resources. If I can figure out as a prosecutor early enough on that those folks really are going to do it, we're going to figure out maybe a way to divide it up, then maybe I don't have to devote as many resources. Now, I'm not going to ask myself, what is the fine or what are they going to do? I now know that in Germany, if they bring those cases and they succeed, that the executives are going to go to jail and they're going to do it. So in one case, maybe we have almost policymakers make these decisions. Maybe in one case, the U.S. has almost no real nexus, and 30 years ago or 20 years ago or 10 years ago, we were the only game in town. Now we're not. So maybe it makes sense on this one, and that's what the prosecutors would say. They would come to my office and say, look, I talked to the prosecutors in Munich, and they're all on top of it. Do you think we should continue with the case, or do you think we should move on to something else? And since there are always more cases than prosecutors, I might have said as the AAG, you know what, let's let them have it. No, in another one, someone said, well, they're on it, but we have a really, really big interest in it. So I might have said, well, why don't we try to divide it up? So a good example is LIBOR. Totally different era. The criminal division started it. It's a huge investigation dealing with an index that it's a totally different issue again, but dealing with the way many kinds of financial instruments are marked. It's an international investigation. It involves banks all over the world. but the index is set in London. So our friends in London now say, well, we want to be involved in this. And so if you trust them and you believe it, then you might do it. So with Brazil, it's been 5 years. The U.S. has some expertise, and they're involved in a case, and the Brazilians are moving forward. They might decide to have parallel investigations, which isn't great, right? They're doing the same thing. They might try to do joint investigations where it's not really joint, but you focus on this, we'll focus on that. Or it might be, what are you doing? It's a Brazilian company trying to get a contract in Africa. Maybe there were 2 meetings in New York, but they're based in Sao Paulo, and I look forward to the day that that conversation occurs, and a prosecutor goes to my successor and says, well, you know, really, successor to Lanny, that's what I hope they called them, successor to Lanny. You know, successor to Lanny, yeah, we have a jurisdiction, but frankly, it's really Brazil's interest, and they're really doing it. And on that day, what should happen is the U.S. says, fine, Brazil, you run with it, assuming it's legit, assuming they do it, assuming there's a track record. But until that day, frankly, what I suspect, the U.S. will keep being involved. At least that's what I would do, and we'll see what my successors do. So it's just a matter of judgment like anything.
Please. Well, first of all, I'd like to thank you for your speech and also applaud your remarkable achievements while in the U.S. government. And also, I'd like to apologize in advance because I'm going to address you a very straightforward question.
I love that.
If you allow me. Lanny, taking into consideration that within the top 10 cases related to FCPA, we only have one unique company from U.S. All the other ones are from different countries. I would like to know, from your perspective, and now taking advantage of your situation in the private sector, how DOJ and SEC are
making the decisions.
Exactly.
Yeah.
That's the point. I asked this question to Chuck DeRoss while in D.C., and he simply said that it's not possible to make, you know, the decision taking.
Who did you ask?
Charles DeRoss from the DOJ.
Chuck DeRoss. He worked
exactly.
for me. Yeah. When did you see Chuck DeRoss?
June. And it was interesting because we were. It was the first week of June during the Compliance Week event in D.C. And when he said, well, it's not possible to have this retaliation against foreign corporations,
right.
in the very same day, I watched in the TV hearing in the Senate, the U.S. Senate,
right,
where the head of the IRS was trying to explain why his staff was targeting people members from the Tea Party
right,
in order to retaliate. So this is my question to you.
Okay, so it's good. So I'm not sure you're right about your statistic. Okay, so the question is, did everybody hear the question? Yeah, I'm not sure that's right even about the top 10, but I'm not sure that's right. But let me go through my anecdote to start. So when I started as AAG, I'd be in the United States, talk about the FCPA, and I would get the following question. I must have gotten a half a dozen times in the U.S. You know, you're enforcing the FCPA more than anyone's ever done before. You're bringing all of these matters. What the hell are you doing? You are completely hurting American businesses when they compete internationally because you're focusing on American companies, and other companies around the world are doing things that would violate it. And then I started traveling internationally, and I would be asked, a little more politely in the United States, what the hell are you doing with an accent? You're prosecuting foreign companies. Aren't you giving an unfair advantage to the United States? So I figured I'm doing it okay, right? I mean, they're both going after me. So here's what I think. you know, I made a list of the cases that have appeared since I left the department, just because I've left the department March 1. The cases were going on, but, you know, I took off 4 months. I was traveling around the world. I did all kinds of fun stuff with my family. So I wanted to make sure. So if you look at it, there's the BizJet case where there was a case against people who bribed Mexican officials. Every one of those in jail is an American, every single one. There's the Parker drilling case. Just looked at that. It was just a couple of months ago, dealing with Nigeria. All of those were Americans. And the next case was a French company, so I'll give you that. Then there was the Ralph Lauren case. That's, I guess, American. I don't know what Ralph Lauren is, but he ain't Brazilian, so that's American. Then there's a case of bribing a Venezuelan government official, and she's been prosecuted for money laundering. But all the people who bribed her, they're American. And then the last case is a French case. So if you look at the last 6 cases, 5 of them were American. Now, you might say, well, I said the biggest, and I'm not sure your numbers are right, but I'll give you my theory, assuming you're right, and I don't think you are. The reason why the biggest cases right now might be non-American is because probably at this day in the year 2013, there's no huge American company that's going to be crazy enough to violate the FCPA on such a massive level, because you know we're going to figure it out because we're going to hear about it, and you know you're going to go to jail, right? So you might violate it, you might be a smaller company, but ExxonMobil is not, well, maybe they are, I shouldn't say, but ExxonMobil, I don't think, is going to, on a massive scale, bribe. All right, so let's look at Morgan Stanley. It's a great example, right? So Morgan, right? So Morgan Stanley is an example. Now, you putting aside the banks, that's tomorrow's lecture. But with respect to the FCPA, Morgan Stanley came to the department and said, we violated the FCPA in China. One of our managing directors bribed a Chinese official, and he entered into a transaction, secret transaction about real estate. But here's our corporate compliance program. Now, it wasn't the kind that I make fun of, like the British one. They had to get me to say it was okay, and Chuck DeRoss. They said, here's our corporate compliance program. Judge for yourself. We trained this guy 8 different times. We trained everybody. Unless we, you know, had like a collar on him and zapped him all day long, what more could we do? So the result was in Morgan Stanley got a complete pass, and the managing director, he's in jail. So I think that if you're right that lately the biggest ones are, I think it's because probably in the natural course of the world, even though now we hear that the major Brazilian companies are more aware of the FCPA. Of course, I'm realistic that there are going to be large companies around the world who don't think they have any connection to the FCPA, who don't care, and say, let's bribe with a $25 million bribe, let's bribe the minister of this and the country of that. And when we find that $25 million bribe or whatever, that's going to be a big case. Whereas probably the American cases, for the most part, we'll see exceptions, are going to be probably smaller in general. They're going to be bad American actors and they're going to be bad foreign. So if your numbers are right, that would be why. But if you look at the total number of prosecutions, absolutely you'll find, absolutely, some years there'll be more American, some years there'll be more foreign, more American executives, more foreign, and it'll have to be totally by where the evidence is in the cases. So thank you for that question.
Lanny, thank you for your talk. As Brazil puts together its new regime and thinks about enforcement, I wanted to ask you in comparative context about 2 particular characteristics of CPA enforcement in the U.S. So within the U.S. traditionally, and now more and more abroad, there's this general critique of anti-corruption regimes on the level of certainty, right? And you made a strong argument in the context of maintaining discretion for enforcement within the U.S. context. But especially as these extraterritorial prosecutions occur, more and more people are saying, okay, this is really hard for us to understand and predict how this American agency is going to enforce its particular statute. So two particular characteristics. One, you mentioned sort of like the traditional issue of should we have a compliance defense? Okay. So it is true you can have like a weak, very formalistic compliance defense, but you can also have a robust compliance defense that's necessitated on the promulgation of like a specific model of like standards for the particular defense.
Right.
So if you're a Malaysian company trying to say like, well, we know that there's this agency in the US and it makes these prosecutions, but we have a completely different legal tradition, we have a completely different criminal law, we don't even know how they interpret these concepts in the same way. If you have maximum discretion, it makes it very, very uncertain for them to make the types of investments to comply. But if there was an actual formal standard that they could apply to, at least it would begin to bridge some of that. The second aspect is the proliferation and use of non-prosecution or deferred prosecution agreements. So for example, you've used that as an effective tool recently, but if we look at sort of like the long-term sort of enforcement, and again, the development of a predictable doctrine, traditionally that's been the role of the judiciary, right? So you come in, increase prosecutions, the next administration comes in and does, we don't know yet. Right? But if we have all these negotiated agreements, then it's shielded from the judicial function of over time articulating in a public realm specific standards by which the statute is going to be interpreted. So how do you feel about the use of those as a long-term goal so that, again, not only domestically where people have made this critique about how do we know what they're going to do if it's purely based on administrative discretion, but for foreign actors who have an especially hard time interpreting these types of behaviors?
So that's why you have such a good law school. You have such brilliant faculty members. So as I said from the beginning, reasonable minds can disagree. So let me start with the first. So, you know, there was a critique and criticism in the United States, as the professor said, that the FCPA is such a powerful law. We need more transparency. We need to understand how it's enforced. Perhaps there ought to be a compliance defense. Perhaps there ought to be more objective criteria so that companies have more notice. And I, by nature, am usually reasonably good about sensing sort of opinion. And so I didn't think, as you know, that that was a particularly productive way to go forward in my mind. And it doesn't matter what I think, it matters what the President and the Attorney General and the Congress think. But that's why in the first instance, I'll get to your point, we created, which is pretty unprecedented in the United States, what we called a guidance. We actually created a book that talked really about how we, the department, I shouldn't say we anymore, I'm not there, but how the department views the FCPA and the enforcement. In the United States, it's almost unheard of, right? In the United States, there isn't a guidance that says, this is how the Department of Justice views bank robbery. This is when you will be prosecuted for bank robbery, and here's when you won't. We think the law speaks for itself, but here we decided to add clarity. Now, when you talk about the Malaysian example, to me, if anything, the discretion is more respectful of different cultures and different attitudes and different norms. Now, maybe I'm wrong, and as I said from the start, you know, I appreciate people who do it differently, but I'm not sure if we said these are the absolute criteria that the Malaysian company necessarily would do it, but maybe they might. Rather, I want to understand in the gestalt of the company, what's the company doing? Where is the company? What's its market? How did it try to mitigate or minimize the chances of corruption? And ultimately, for me, and I understand what you're saying, different regimes will do it differently. I want the Chuck DeRosses of the world and their team to sort of be able to evaluate that. And I guess I don't believe, but I might be wrong, that laying out exactly what the compliance program needs to be is the solution. And frankly, I don't really accept the fact that it's so hard to figure out what the department is looking for. I think there are the principles of corporate prosecution. There are now so many NPAs and DPAs, and I'll go to that, and resolutions that in the FCPA area that are online, so you can read. The Ralph Lauren case got resolved. This is the basis for it. This is why they did it. That I think if you want guidance, it's there. But I think the existing way of doing it gives still the department more discretion, and I'm hopeful that the department will use it wisely. But I understand the debate, and we can talk about it all day, and there'll be people who say the very way you just argued it shows there's too much discretion, and there ought to be more objective criteria. In my view, would be those objective criteria aren't going to get you what you want anyway. Different people are going to do it differently, and then we're just going to be fighting about, did you do A, B, C, and D, or didn't you do A, B, C, and D? And if you did A, B, C, and D, you think you win, and I don't want to be there. I want to be able to look at it more broadly and be able to say, what did you achieve? So that's that one. On the NPA, DPA, so let me go back. It used to be in the United States, and it's in many countries, that you had a choice when you were looking at a company. You either prosecuted the company or you let the company go. It was a binary choice. Prosecute, don't prosecute. We saw in Arthur Anderson, they had to choose. They chose prosecute, and thousands of innocent people lost their jobs. Now, those of you who are bored, you can look, you can read about this debate in the United States. You'll see there are many people who criticize me for this view, but I'm a pretty direct guy. I say what I think, and I believe that binary choice is terrible. And I think for all the people who say that's the only way you get tough on a company, that the only real people who you get tough on are the people who had nothing to do with the crime. The people who lose their jobs when a company has to plead are the secretaries, the assistants, the lower level people. The senior people do just fine. So it's, in my mind, an absolute fiction, and it's purely playing to people's emotions to say we're going to hold XYZ company guilty no matter what. Because the only people, either you go after the executives, which we have when you can, but just hold a company criminally liable to say you do, I think only hurts those people. Now, having said that, we created these NPAs and DPAs that have lots of conditions. And I do accept, Professor, your view on one thing, and it's evolving, and I probably, to the shock of a lot of people, think it's probably a good one, which is, it used to be for today's discussion, whether we talk about a non-prosecution agreement or a deferred prosecution agreement, it's not that consequential for the debate. But it used to be company comes in and says, we don't want to plead guilty, we can't plead guilty. Government says, well, we think you should. There's a discussion, and maybe there's a compromise, an NPA, a DPA. But you have to meet the following conditions, or you will be prosecuted, and we'll defer it. So in 5 years, we'll look and see, did you do the things you said you had to do? If you did the things you said you had to do, we'll dismiss the case. If you didn't do the things you said you do, then we still can prosecute you. And judges played very little role in it. Really, the idea was they'll only play a role if you didn't do it. In 5 years, we'll go to the judge, we'll say you didn't do it, and it'll be a bigger punishment. Recently, and what I'm very proud of, but it's been criticized, in the largest case probably in the United States in years, except for the BP case, which we did, is HSBC. And in HSBC, there was a deferred prosecution agreement. And a very smart, very tough judge in New York, Judge Gleason, who used to be an organized crime prosecutor, said, hey, wait a minute. If you're going to have a deferred prosecution agreement in my court, in something this big, I get to judge whether I think it's appropriate or not too. I'm not just window dressing. We get to look at it hard. And in that case, Judge Gleason looked at this HSBC matter that's been the subject of, I think, pretty irresponsible discussion by people who didn't really read the deferred prosecution agreement, didn't really look at the underlying facts and the evidence. And Judge Gleason, who's tough, said, look, I reject the government and I reject the HSBC defense lawyer's view that the judge doesn't have a role. I have a real role. So let me tell you, I've looked at it. And what's my analysis? My analysis is that this is a rigorous, these are my words, but you read it, this is a rigorous deferred prosecution agreement. Indeed, it's questionable whether the government could have achieved as much had they prosecuted HSBC. There's an international monitor, et cetera, et cetera. So I don't mean to over-argue the HSBC, But I actually think that NPAs and DPAs are a very important tool. I think they give the government more discretion than when it was a binary choice. I think you see now that the government has prosecuted. They prosecuted UBS and RBS in the LIBOR matters and forced them to plead guilty. But I think probably, Professor, as you're suggesting that, and probably my future clients will be upset that I'm saying this, but I do think it's probably it's the evolution in the United States. We're at the beginning of it. I think it's probably a constructive evolution that judges will play a role or more of a role in determining whether or not they feel that the contents of the DPA make sense. But I'm a huge believer that DPAs and NPAs are good, and you just have to keep using them.
Well, just to follow up very briefly, just specifically besides their legitimacy, as an enforcement mechanism, but what about their role in promoting certainty over the long term in the field, so that, again, so that domestic and international actors can predict this? That's what I'm talking about, the judicial function, not just simply in reviewing like plea bargains.
I don't know what certainty means, right? In 2000, I really don't know what certainty means. I don't think in the, well, let me tell you.
Case law.
Well, case law, you know, in the every criminal case is different. Every by its definition. And in all due respect to an academic institution, at the end of the day, when you're going to try to figure out how to resolve a case, it's got to be based on the facts and law. I actually don't buy the notion today. I just don't buy it. And I actually, that there is so much question in the world about how the United States enforces the FCPA. If anything, it's more clear. If you look at most of the cases, there are very few people who say, is that a bribe or not a bribe? They're bribes. They're big bribes. I think that the discretion has been making the cases more and more robust. And I don't think, I don't know what certainty is. If you said, we're not going to use DPAs and NPAs, we're just going to prosecute, the only certainty is that very few companies would actually, in the end of the day, be prosecuted. Because at the end of the day, somebody in my job is going to have to decide, and maybe now it'll happen. Look, in banks it'll happen, but there will be times that you will need the discretion. And if you don't have the discretion, you're still going to have to make a judgment. Do I prosecute? Don't I prosecute? So it's not going to add clarity. It's just going to say DPA is no longer on the table. So frankly, I think as we've done more and more, there is clarity. Maybe not in an academic setting, but in a real world setting, I think most companies understand today that within an ambit, they have to have a compliance program. I think they have them now. They can debate whether they work or not. I think they will come in and they'll argue, we think we deserve a DPA. Maybe they'll get it. Maybe they'll have to plead guilty. I don't think ahead of time you know, just like when you're an individual and you commit a crime, you don't really know ahead of time, am I going to be prosecuted for A or B or C? And I don't think in Brazil you'll know it if they have different statutes than in the U.S. There's always going to be some level of judgment. I think what you want to have is you want to make enough of a deterrent to encourage good conduct, and then sort of have sort of a universe, maybe a more narrow universe, of the likely outcomes. And maybe I'm naive, but I think that the current regime promotes that.
Just to add, I think what happens a lot with this lack of judicial review is this extended jurisdiction that the DOJ interprets that the FCPA has. I am not sure that once you do have a judicial review that, like you said, because you use the U.S. bank, you automatically have jurisdiction. Perhaps I think there may be more certainty when you talk about the jurisdiction of the FCPA once you have more judicial review over that.
Well, look, it's a debate, and we'll see. I mean, I think most companies that come in, frankly, don't want more judicial review, right? They want to be able to make their case. They want to explain the circumstances of their case. They want to be able to compare it, which they always do, to the prior cases, which they're able to do online. Companies always, of course, do have the discretion to go to court if they want. No one can force a company not to do it. But I totally accept the idea, as you and the professor are suggesting, that if more DPAs have to be in court, then of course there'll be more cases. But of course, we have a couple of thousand federal district court judges, and they're going to look at it totally differently. And I don't really believe that case law is going to solve it, because every case is different. So a district court judge in Texas may or may decide that the case in New York is similar, or it'll distinguish it the way you distinguish cases today. And if you look at, for instance, today in case law, you look at our sentencing guidelines, which are advisory. Mm-hmm. There are jurisdictions and where 25 to 30% of the cases are within the guidelines range. And there are other jurisdictions in the United States where 75 to 80% of the cases are in the guidelines range. Being in court has not in any way added to any predictability or consistency nationally. So it's just a discussion, and it may happen, and when we all come back in 5 years, we'll see.
And just adding what you said about most companies not wanting to be in court, I agree, because the publicity of fighting a corruption case is much worse than the publicity of a company that comes to an agreement or cooperates. And I believe the Brazilian law kind of goes into this public shame when some of the sanctions that are found here is a publication of the company that is found guilty and a database of guilty companies. So I think it goes back to the idea of not going to court and not being found guilty as a corrupt company.
And one thing, and then I'll stop, but one thing that just occurred to me that I think could be an unintended consequence, and we'll see. But I think if more companies perceive in the next years that, let's say, in cases that are resolved through deferred prosecution agreements, those are only some. I mean, there are many, many companies that are forced to plead guilty, and if you look at the numbers, that numbers only increase a lot. But I think as courts get more involved in deferred prosecution agreements for the very reason you've suggested, there will be some cohort of companies that now are willing to voluntarily disclose because they think that they have enough of a case because of what's online and everything, that they think they have a pretty good shot at getting an NPA or a DPA, and so they'll come in. But now if they say, oh, wait a minute, there's one more hurdle, we also have to convince a judge, there's going to be some percentage of companies that say, forget it, let's not disclose. Let's keep it quiet. Let's take our chances. And I'm not sure for the benefit of the public good. I mean, that's like everything. Every time you make a decision, there's going to be some consequences, and I think that is probably going to be a consequence, and policymakers, and we can decide whether it's worth it or not. But I think that'll happen. There'll be some set of fewer companies that'll disclose.
Yeah, in Brazil it will be a problem because the enforcement will be done by several different bodies on the federal, state, and municipal level. But on the other hand, we do have the obligation to prosecute both in the administrative and the criminal levels. So it will be very, very hard. Maybe a guidance would be a very good idea, federal guidance that could regulate what states and local mayors can do would be a good idea. Okay, I would like to thank the audience and thank a lot, Lanny, Breuer, for your very informative talk. And we hope to have you here before 5 years. Okay?
Thank you very much.
Thank you. Good night.